Hello, everybody. It's James Donnelly returning to host the Association Leadership Series. I'm the founder and CEO of the Castle Group. And today we have special guests. I see Gary Mars, shareholder with Siegfried Rivera. And Gary, I think we're missing one of your partners who hasn't arrived yet.
I don't know where he is, but let's try to find him.
Yeah, I expect him to arrive shortly. Gary and I go back literally to the beginning of our careers in this industry. Gary, I remember meeting you for the first time in our old office up in Sunrise. And I think you've been at Siegfried and its predecessor 30 years now.
Yep.
Maybe while we're waiting for Roberto Blanche to join us. There's Roberto.
There he is.
Roberto, welcome. Roberto Blanche is also a shareholder at Siegfried Rivera. And I was just going back about our long history together here, Roberto. Gary, before we get going, I know you guys do lots of webinars, as do we, but I haven't had the honor of just having you two on our series previously. So maybe just give us a quick background on the firm before we jump into the topic. I'm sure our audience would love to know.
Well, the first question I have for you is, why does your picture look so much better than Robbie's and mine? But we'll talk about that another time.
It's always good. It's always good to be the host, Gary.
It is. So first of all, I want to thank everybody for joining today. Robbie and I are both shareholders with Siegfried Rivera. Firm has been around for over 40 years. We are, as we describe ourselves, a traditional dirt boutique law firm, meaning we are dealing with community associations as one of our principal areas of concentration. We also do construction work and all various different fields typically in the commercial side of construction. And the third area of practice is essentially commercial real estate, which again, we have three really, very thriving departments dealing with those three areas. Our firm is about just north of 45 attorneys, and we are central offices in Coral Gables, but we have very active offices in the Fort Lauderdale and in the Palm Beach markets, both in West Palm Beach and in Fort Lauderdale. And we are, very, very active, particularly today's call. Community associations is one of our core areas of practice, and we, pride ourselves on staying cutting edge in that regard and providing our best and most efficient service for our community associations that we represent. So we want to thank Castle for putting this event together. And, we really love having this opportunity. So thank you.
Thanks, Gary. Thanks, Roberto, and welcome. Just a reminder to our participants today, if you have any questions throughout the show or after, you can always email them to info@castlegroup.com. We do have someone monitoring that throughout the show. And of course, the chat feature is live. What we'll do today, we have some very specific topics on returning to normal and COVID and vaccines, but always try and incorporate your questions as we go along. I also want to remind our audience that Gary and Roberto are sharing their brilliance and their time with us, but not to be perceived as legal advice for you, unless maybe you're a Siegfried client. And we're also going to do some polling today. In fact, I would like, well, let me go over the agenda first, but you guys had asked Gary and Roberto what the audience would be like in terms of demographics. So or in terms of the types of communities. So I'm going to ask that question in a minute. But so today we really are, thank goodness, getting back to some semblance of normality. And we've just had a bunch of legislation pass. And so what we really want to share, and especially with Gary and Roberto, because they bring a new perspective to the shows that I've hosted on the impact of all of that in terms of us as board members trying to manage and guide our communities. And so we're going to do a bunch of questions on that. I'll give you a quick update on some data points on COVID and the vaccines, and very brief on legislative update since our last show. But I think, Mariness, if you put up poll question one, we haven't asked this for a while in our series, but we're just trying to get a flavor today for what types of communities you're being leaders in right now. And while they're voting, Gary and Roberto, I just wanted to give you some numbers I checked this morning. It's really interesting. We serve both the Texas and the Florida market, and I know I'll only ask you Florida law questions because that's where you practice. But the Florida and Texas have really followed a similar path with this COVID journey. And I noticed this morning we're getting about 2,000 cases in each of the states a day, which is still significant, but way down, and a fantastic sign. In fact, on the vaccination front, I noticed Texas has got 43% of their community receiving one shot, Florida 47, and 35% of Texans are completely vaccinated, 37% of Floridians. Interestingly, that's not anywhere near the kind of the herd numbers we've heard about, but the numbers sure coming down. So it'll be interesting to see where that all goes out. Okay, let's share the results so Gary and Roberto know the community or the numbers. We have 16% HOA, 34. So half of them HOA and half condo or co-op. That's interesting. Sometimes we have a little bit more of one or the other, but there you go, gentlemen. We will be able to know exactly, target our responses accordingly. Two things I wanted to update our listeners on, and maybe Gary or Roberto, you can even comment. First of all, just going to cover Texas. There was a executive order 36 on May 18th that basically ended all COVID restrictions. And similarly, 21-102, the executive order here in Florida, I think had a similar impact. Gary, Roberta, do you want to comment on the most recent executive order from the governor?
Yeah, sure. So you're accurate, James. So Executive Order 102 was the order that the governor signed about a week and a half ago, suspending all COVID-19 restrictions or mandates on individuals and businesses. So, this has created a lot of questions on the community association. Again, this doesn't matter whether you're condo, co-op, or HOA, it doesn't matter. It applies across the board statewide. What in essence it did was it lifted all municipal, county, and any statewide restrictions that may have existed were affected by the suspension, which again has now brought many questions back to the properties about how do we execute for our particular communities. And I'm certainly talking about that, I'm sure, through the course of this, but yes, that's the order that lifted those mandates.
Yeah, and you know what, Gary, I like to kind of go with the flow here. I mean, we're on this topic. How does this order apply to our associations? And do we have to kind of follow it to the letter of the law, or because we are separate associations, we have more flexibility than I know businesses would have under this order? I'll open that to Gary or Roberto. Yeah,
sure. So the associations are predominantly able to establish their own rules and regulations, as we all are aware. That rulemaking authority gives them the opportunity of creating reasonable rules and regulations which protect the good and welfare of their property. So, we're not, when we as a law firm have been advising our clients to create of recent time, I'm not talking about when this pandemic first started in March or April of 2020, but as time has gone by and other rules have either been revised, modified, lessened, whatever the case might be, the rulemaking authority in that regard has been the association's empowered rulemaking authority. So it is not based on really the executive order. The previous executive orders have been helpful, and they've been helpful in defining the rights, but community associations are universally empowered to create their own rules and regulations, including rules and regulations which may include some level of either mandate or recommendation involving either mask wearing, social distancing, things of that nature. So the short answer is it's up to the association. Most associations, unless they have some very, very strange restriction, should have the opportunity and ability to create their own rules, which impact even things involving COVID-19 effects.
I'm going to ask Mayor Ness to put up question 2. We've been kind of having side bets here as to whether that executive order will get extended, and we keep thinking it won't, and it gets extended. So I'm going to ask my audience what they think. But Gary, you bring up a really good point, and it's a very confusing point for associations, and that is, we've always had rules in our communities. I'll use an example. The pool closes at 10 o'clock at night. That the board, whatever, made a decision that was an appropriate rule. And during COVID, obviously, they made a rule the pool closes completely. But your point, I think, that I want to reinforce is that our board of directors have the authority to make reasonable rules and reasonable changes when you have special circumstances, hurricane, pandemics, and whatnot. And so I think that is, as board members, we're looking to external inputs, but I just wanted to reinforce to our audience that, they have this rulemaking authority all along, correct?
That is correct. So you got to remember when this pandemic first started, the associations were, as everybody, we were immediately faced with some urgent, emerging, imminent type concerns, and there had to be some serious decisions made on things that we hadn't really addressed before, like pool closings and closing down common element facilities and mandating mask wearing. And, we were going through all of those, including delivery issues and guest issues and all of that. So there was some very, 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 very urgent needs to take, if we were following what we were being instructed to take, take these actions and to codify them in a correct manner. So, the executive orders that were provided by the governor helped, instruct us and inform us on some of those parameters, and they also empowered the association to make certain decisions, including some that may not have involved, a formal board meeting in the context of a 48-hour notice meeting or whatever your documentary requirements are. So we were on those executive orders as this, situation was presented to us to, and not in all cases, but in a lot of cases, to make some of those decisions that had to be made, possibly even in the management's office, the manager's office, just because decisions had to be made. As time has gone by and we're back to more of a regulated opportunity to call a 48-hour board meeting and to put out information to the unit ownership, and again, the imminency of all this kind of has kind of, stopped. Most of what, we are dealing with regard to rulemaking, decision-making regarding COVID-19 is really falling back on the association's general rulemaking ability. We're not really needing to rely on the executive orders provided by the governor. So this emergency order, concern and whether or not it has any real direct impacts on these discussions, in my opinion, the answer is that it does not. So, or it has not for quite a while. So in the event that in the context of community associations making rules involving COVID-19, the fact that there is a emergency order that is lifted, I don't believe that will have any effects on the association's ability to continue to make reasonable rules and regulations for the good and welfare of their population.
Thanks, Gary.
James, if I can add.
Yeah.
If I can add just one.
Go ahead, Roberto, and Marinus, share the results, please. Go ahead, Roberto.
Yeah. So just to add something to Gary's point, the rulemaking authority does give the association broad discretion to make rules and regulations that are reasonable. But what the associations have relied upon the emergency powers for are other issues, such as the manner by which meetings are held, whether elections or budget adoption meetings could be postponed or held in some other type of virtual context, as opposed to the traditional in-person venue. And so because of that, we've relied upon, to some extent, the emergency powers that does hinge upon and relies upon the governors or some other state agency or governmental agencies issuance of an emergency order. So while Gary's point is very good as it relates to rules and rules not depending or hinging upon exclusively the issuance or continuation of an emergency order, there still remain other flexibilities, let's call them, that we have been enjoying over the past year that to some extent do rely or lean upon the emergency powers. And when we discuss the legislation aspects of it, we'll see what the legislature has done to address some of that.
Excellent. I just wanted to share these results. So I asked our audience, do we think they'll extend it again? And it's predominantly no. And guys, I share this feeling. In fact, one other element I wanted to share with our audience, especially for the self-managed communities, we've had a really tough time hiring people in the kind of under $20 an hour because the unemployment benefits have been so great. Well, the governor has announced that as of June 26th, they will no longer opt in to the additional $300 of unemployment insurance. Same thing in Texas. So what that means is that to be unemployed, you're only going to get $275 from the state, not $575. And the reason I'm tying these things together, number one, this will make it easier to hire people. I won't comment politically whether it's the right thing or the wrong thing, but it is what's going to happen in Texas and Florida. And so people who are kind of sitting in the sidelines waiting to get back to work for whatever reason, many good ones, I think we're going to see easier to get hire people. But if he's announcing that as of June 26th, it happens to be the same date that the emergency order is over. So I'm guessing that that is not going to get extended. I had a couple of questions here, and they're related to this. So, in fact, no, I'm going to go into there's all the discussion about vaccination. So the first question we have on the board here is, can an association demand proof of vaccination from residents to access a clubhouse? And I know we're getting this question a lot, and I don't think the answer is necessarily black and white, but can you guys kind of give us a overview of the decision-making process for a board member in terms of, mandating vaccines or asking for proof? And if I can just set that up for you, in terms of CASEL and our corporate policies and our current policy, we're not demanding vaccination, and we're not asking for proof of vaccination at this moment, but we are still requiring masks on at work. And our theory there is, I know we have communities that are relaxing the mask rule, and that's great, but we as the management team are not going to be leading in that. We hope to get to the point where we can all unmask, but we're not requiring vaccination, we're not requiring proof, and we are requiring masks from the employment side. But the question here is, I'm on the board, can I demand vaccination for access to Clubhouse?
Yeah, that rule, we have had to deal with that question for quite some time since vaccines became available in our community. And the issue is, for those communities, or at least the conversation I've been having with my clients consists of the following. If you want to require this, technically speaking, you could. But I end up telling them that they have a whole bunch of reasons why they either shouldn't or may have problems in the event that they make this an issue. So, you kind of have some individuals on the boards that want to require vaccination to be able to walk around without masks, or to be able to use certain facilities or make it mandatory. And then we start having a bunch of other issues with regard to the enforcement of it, right? How are you going to know, for example, somebody who's been vaccinated? How are you going to be able to prove it? If you've been vaccinated, it still isn't a guarantee that you're not going to get infected. Do we embark upon some privacy concerns or HIPAA issues? Not that HIPAA is going to apply to us per se, but privacy issues. There are also the establishment. If you look at what the governor in the state of Florida did, he spoke out against what he characterizes as vaccine passports and started alluding to the fact that this creates, in effect, two classes of citizens and all of the consequences that could arise as a result of that. And this similarly can rear its head in community associations. So there are a whole bunch of reasons why this becomes a difficult policy to apply successfully. And because of all these issues, my suggestion during these conversations with my clients is why create this policy? You know, that's become my conclusion. And I don't know if Gary, I'll let him speak for himself, but I don't know if Gary has a different approach to that. But I tend to think that this has become complicated enough over the past year to insist upon people wearing masks to now create another level of complexity. And so most of my clients, what they've ended up doing, which they could, as we discussed earlier, and as you have indicated, Castle has also done, is most of our clients have continued the request and the requirement for wearing masks, especially within interior areas, within areas where individuals are going to be in close proximity to each other. They may, for instance, be relaxing them on pool decks, where you could be of larger distance from other individuals, or you've got the exterior elements, you know, are more conducive to taking off the mask. But we have seen with my clients, I have seen some relaxation of the mask policies in certain areas, should conditions merit it. But I have not seen, for the most part, a complete elimination of masks, nor have I seen any of my clients adopt a mandate for vaccines or a concept that would be analogous to a vaccine passport.
Okay. Gary?
So just to bridge that, so Robbie's on point. There's a whole litany of issues that come up with regard to that mandate of requiring, vaccines and what that means. And we have, I may refer to this a few times in this webinar. There is, each one of these buildings has what I call, and it's been commonly referred to as a patchwork scenario, where we have a whole different variety of individuals living. I mean, we have to remember this isn't a single family situation. This is a community association with many unit owners and guests coming onto the property, and vendors and employees. So, having a mandate for or a rule saying that there's some sort of requirement for a vaccine is on many levels, and you do need to consult with your attorney. I think there's a whole variety of different issues, several of which Robbie pointed out. Another issue also to add to those issues is, I'm going to refer, again, playing lawyer for a moment, Senate Bill 72, which is another piece of legislation which came out, which is a civil liability for damages relating to COVID. So right after the mandate for lifting, masks wearing as well as social distancing ordering came out, or mask wearing predominantly from the governor, a second bill was first introduced as an executive order, and then has been codified in the statute as a law, which now establishes that COVID-related liability protections for businesses and healthcare providers, institutions, et cetera, not-for-profit, such as community associations, establishes what the limits of liability are. And the limits of liability have been established now as being a standard of gross negligence or intentional misconduct. So in order for any institution, condo or homeowner association included, to have even bear any kind of liability, the liability would have to rise to a level of gross negligence or intentional misconduct, which is a very, very high standard, in the law. So individuals who want to file a lawsuit have to provide an affidavit. They have to have a medical professional asserting that they contracted the virus at the corresponding property. They need to demonstrate clear and convincing evidence. Again, sorry for playing lawyer, that the misconduct or negligence of, in this case, the association was the cause of their illness. And, so it's a fairly high standard. What has thrown some associations off, for those that have looked at the legislation, is the legislation also recognized that the association, in this case, or any entity, should make a good faith effort to substantially comply with authoritative or controlling governmental issued health standards. Now, remember This came out a week before the CDC relaxed its requirement and made it it was always a recommendation, but where they lifted and changed their mask and social distancing dicta. And so when this came out, we were initially looking at the CDC as a guideline, but now it doesn't exist. So we're back to full circle to the boards having to evaluate, make a good decision based upon the practical issues on your property, evaluating this patchwork effect. Each building has a little bit of a different approach to that, and designing a set of rules and restrictions that will, best suit. Again, I'm talking predominantly about COVID direct related mask wearing, social distancing, what rooms are being utilized, whatever. Robbie makes a bigger point to the fact that there are other issues to consider, and I'm not really considering them for this moment, including how we're conducting our meetings and uses of certain facilities and things of that nature, annual meetings and how we're conducting our meetings, things of that nature. So a lot of information board needs to consider.
I'm going to ask Mayor Ness jump question 3. Put question 4 up because it's right. It's the are you relaxing your mask question. And Gary, this really segued nicely into the flow. I wanted to get into some of the legislation, and you brought up 72, Senate Bill 72. Could you just take us back one step? The need for 72 was the fact that a lot of our associations had, I believe all of our associations had no insurance coverage for this, and our associations would have been terribly exposed, but for Senate Bill 72. Was that the real driver of this from the legislature?
Well, I wish it was only about associations, but to your point, I think there's an issue with that, insurance wide with regard to coverage and things of that nature. And then there's that also maybe a little bit more practical issue that why would we relax some of our requirements if we may have potential liability? So I think the governor, aside from the question about what gaps there exist in liability insurance, the other question is I think that there was a motivation to try to get back to normal, and how are we going to do that if there's a potential of liability each entity where a guest is visiting, in the case of a community association, a resident and or guest comes onto property, or a vendor, if they're exposed to that level of liability or a level of liability which is at a more average standard like negligence, is it really going to be effective if we have that type of restriction and we lessen some of these or loosen some of the requirements? What is the real impact going to be?
Yep. Mayor Ness, share the results of that poll. I think it's very interesting. This is what our audience guys have done on the mask policy. So yes, half, no, a third, and partially. I just wanted to share with our audience a couple of our observations from the management side. Like, I live in a high-rise condo building, and they have said if you're vaccinated, you don't have to wear a mask, period, except the gym. But even in the elevators, you don't have to wear a mask. So it really puts, and there's I shouldn't say of course, there is no requirement for us to prove our vaccination, which has kind of flipped the onus to those who are concerned to wear a mask. So I do want to share with our audience that out in practice, we have a lot of our buildings, and you can see that in those poll results, that are that are starting to make those relaxations. Gary, so you've put us into legislation, and Roberto, I really want to ask you, there's this monster bill that affects everyone listening to this, 630, and without going into the detail, can you kind of give our audience some highlights about what was in that and how it would impact us, Senate Bill 630?
I'm going to do my best to give those highlights in a very brief manner, because we're dealing with a 101-page bill, which does cover a very broad stroke of issues that we deal with in community associations, both cooperatives, condominiums, and homeowner associations. And as a result, you're going to see that some of these provisions within the bill apply to the 3 types of community associations, and some other provisions are more unique to one type over the other. So right off the beginning, what the bill does is it included of great relevance, I think, a provision in Chapter 627 Florida statutes that pertains to the insurance within the state of Florida, and this is to curb some of the subrogation claims that have become very in vogue over the past few years with regard to unit owner insurance policy providers subrogating against the associations for some of the damages that they've had to pay out to their insureds. And so that provision basically says if the condo association's insurance policy prevents it from subrogating against the owners, then the owner's insurance policy cannot subrogate against the association. So that hopefully will give some reprieve to the associations by way of protecting their insurance, their insurers.
And Roberto, this is super
Yes.
important because our insurance rates are going crazy. This will help the insurance company. Like they're not going to have those additional claims that are subrogated from the homeowner policy. So I think this is a positive, don't you, for our associations? And
yes, sir. And that was the intention of this legislative change. You know, the insurance industry lobby, of course, as you pointed out, states that it is running huge losses as a result of all of these subrogation cases, and therefore this, per the lobby and per the insurance industry, will alleviate their losses, which in turn they claim will directly benefit associations vis-a-vis rates. Now, again, we shall see how that pans out, right? So let's see in time what the impact of this change is for associations. But it is I consider it to be a good change. One of the other provisions that came up with regard to legislation in previous years was the ability to extinguish or eliminate from governing documents any discriminatory provisions, right? Some of our more old-fashioned communities that were established, decades ago might have some provisions that are shockingly discriminatory. And so what this provision now did is it indicated that not only are you allowed to do it pursuant to Chapter 712 Florida statutes, but now all three chapters, 718, 719, 720, dealing with our three major community association types, provide that there is a mechanism to eliminate or extinguish discriminatory provisions from the governing documents of an association. We also find some clarity with regard to term limits. As you know, board of directors that have served condominium association boards for more than 8 consecutive years are limited as to their ability to get reelected. In other words, if they serve or stand for reelection, they could be reelected if elected by more than 2/3 of those voting at the election. Otherwise, they would be term limited. What this provision did is it establishes that you start counting that 8-year term of service as of July 1st, 2018, which is the effective date of that most recent change to that section in Chapter 718.
I think that's important. We had a lot of questions from people. When does the 8 years start? So this is very clarifying.
Yes. So there was a division of condominium declaratory statement initially when this came out that confused everybody, and that was the Apollo case. And then there was a reversal, let's call it, of the division, but this now codifies it legislatively. We also find that Chapter 718 allows an increase for transfer fees from $100 to $150, and it also provides for an increase for every 5 years based upon what the CPI increases are. I do want to mention, however, for everybody listening to this webinar, that This has not yet been signed into law. It's been, it is expected, those that have money writing on this, I think, presume that it will be signed into law or become law, but as of yet, it has not been. So let's keep that as a proviso that if there should be some issue or veto, which we don't anticipate, this could, all of this could be for naught, right? Just trying to run through it real quick. If you recall, electric vehicle charging stations, the legislature a few years back established that that an association couldn't impede an owner's ability to install charging stations within their parking spaces of a condominium, and also provided for some protections for the condominium association to the extent that a unit owner wanted to install those electric vehicle charging stations. Curiously enough, what the legislature did here is that they've extended this not only to electric vehicles, but also to vehicles that run off or on natural gas.
Yeah.
And have also provided that you cannot impede an owner who wants to have a natural gas pump station within their parking space. Now, in most of the condos that I represent, I mean, it's difficult enough to fit a car within those spaces. I don't know how you're going to put a natural gas natural gas pump station, but you know, I guess this is something we all got to keep an eye out for should it arise.
I actually have a question on that while you're going on. Mariness, put up question 8. I'm just interested to see how many of our communities have those charging stations. But please, Roberto, keep going on your 6:30 summary.
Sure. Yeah, there's another move in Chapter 718 as well as in Chapter 720 and 719 to promote not only the arbitration that we see in condominiums with the division of condominium, but now they're broadening the ability of owners that are parties to disputes to be able to file in court and not burden the division. So that's an option or discretionary provision there. And also, the parties can elect to mediate as opposed to proceed with non-binding arbitration. So, and there are also provisions allowing for the parties to make the decision in arbitration final. So there are nuances there. And the big one that I wanted to touch upon is the emergency powers provision. In all 3 chapters, there are now revisions to the emergency powers to cover not only what some characterize as the original intent of the emergency powers provision, which was to cover natural disasters, but such as hurricanes, floods, fire, etc. But now they're also extending it to contagion, to infectious situations, to circumstances that may not only cause damage, but may also cause injury. And so now what they've done legislatively is expanded the scope or the applicability of the emergency powers for condos, co-ops, and HOAs to cover those types of pandemic-related situations like what we've encountered. It also expands that no longer do we need to deal with emergency orders necessarily, or what the county or the government might order or the city, but now we could also focus on what certain officials like the CDC and some other, officially recognized health agencies may promulgate or may recommend. It provides for relaxed and more relevant provisions pertaining to how to conduct meetings. Can you suspend or alternatively conduct your board meetings, your elections, your budget adoption meetings electronically or through some other types of media that were not originally contemplated in the original version of the emergency powers statute?
Roberto, we have a question on that, a couple of questions about does this allow boards to go or like, will boards have to go back to live meetings? That's the question on the board here, on the chat board. Does this help us, this provision of 630, by saying, no, you don't have to go back live? Does this allow us to continue to do them electronically?
I don't read it that way, because all these changes contemplate the relaxation of your traditional attendance, right? Your meeting attendance and how you conduct your meetings. What this provision does is it embeds it within the emergency powers section, which is, for instance, 718.1265 for the condos, and for the HOA 720.316. And so by virtue of doing that and embedding it in the emergency power section, then it contemplates that this relaxation is conditioned upon some type of emergency situation. And absent those emergency situations, then you should resort to the traditional means of conducting and hosting meetings.
Okay.
But just to add to
curiously,
that, I think the statute also is making allowances. It's not extremely clear, I think, and it's something we're going to have to work out. To be able to conduct a regular meeting, virtually, was something that was previously already contemplated. So the concept of speaker phones and virtual meetings and in-person meetings, the question is, can we do only, which I think is what your questioner is asking, only a Zoom meeting? Do we have to have a physical meeting place also? I don't think that that's really, I'm sorry to say, I wish I could give you the legal answer. I don't think that that's incredibly clear. But there have been many associations that, for example, just using speaker phones as that boards just aren't showing up. There's, they're not in the South Florida market, and people attend via speakerphone, and I believe virtual meetings are included in that. So I think we need to, you need to stop by your attorney and have that discussion, because I think there's probably going to be some level. I appreciate what Robbie's saying, which is clearly about emergency relief through the new legislation, but the question also is about appearing virtually, and I think there's allowances for that, and I think we're going to figure it out and see if it's going to be able to stay in the same format. So I think it's something you need to stop by your lawyer and have that conversation.
Well, we've been talking throughout this series about the need to amend documents. Just to that particular point, guys, despite what the legislation says, could we put in our own documents provisions that, yes, we can hold all meetings or whatever they want virtually? Can we do that through a document amendment?
The concern I have with that, first of all, I think you can make the amendment. Now, whether the amendment may be effective or enforceable, I think becomes a different issue. So an owner who, for one reason or the other, cannot attend or refuses to attend or prefers not to attend virtually, are you in effect depriving them of their ability to participate if they insist on attending in the absence of an emergency situation in person? So that's something to take into consideration. And yet with that in mind, you also recognize, a la the Woodside cases, all these provisions that provide condominium and homeowner associations with the ability to amend their documents, and the fact that owners that have purchased in those communities acquiesced to the reality that their ownership interest is subject to change to the extent that amendments to the declarations are adopted. So I think it's a very good point you raise. I'm on the fence on that as it stands, and I think time will give us some guidance, because one of the points Gary mentioned earlier, we've become very loose in the past year with regard to unit owner participation vis-a-vis these virtual means or methods, and so what happens when somebody can say there is no emergency or no unsafe condition, or we've all just become so desensitized to it, right, that it becomes part of our normal life? And absent some clarification from the legislature or from the Division of Condominium, for instance, can an owner speak at a board meeting? Does he have the right to speak at a board meeting, virtually? And can we insist upon that? Can an owner vote and participate on a Zoom call? we know there are the means to adopt electronic voting, and there is a procedure set for that. But absent following that procedure, which only gives you the right to vote electronically, is there a parallel right to speak and partake in the meeting virtually, much the same way we are speaking to each other right now for unit owners? And we know traditionally the board has that right because the statutes do give the board the right to appear and count toward quorum, the board members, if they do so virtually at the meeting. So I don't know how we're doing on time, James.
Well, Roberto, let me do this. First of all, share the results. I think this is interesting on the electric car charging. And then we also had a poll question, whether our communities are going to return to in-person meetings. So it looks like we have very few with electric car charging. Marinette, put up question 6 while Roberto finishes 6:30 comments. We have about 10 minutes left, and there's 2 other quick comments I want Gary to make on 2 other bills, but what else do we need to know about 6:30?
Just 2 more quick points. One of them is that for homeowner associations, we know there's this big desire that the legislature has for records to be made available for inspection by homeowners, and the same applies for condos and co-ops. And then there are also these protected records, records that are not accessible for inspection. Nonetheless, the association needs to keep those records. Yeah. What the legislature did for HOAs is they expanded the list of protected records to include information that an association may obtain in a gated community regarding the guests that visit parcel owners or community residents. So now if you've got some of this info regarding who's coming in and out of the gate to visit people, that info now is going to be protected if this bill gets adopted. And last, there would be an amendment or a revision to the statutes with regard to amendments that could be enacted to homeowner association documents that may limit or curtail the leasing of units. And it's not exactly like what we find in the condominium statutes regarding the grandfathering scheme for certain types of leasing restrictive amendments, but it is something that community associations, HOAs, are going to have to keep an eye out for, and if and or to the extent HOAs are looking to amend some of their leasing restrictions, I believe a call to your lawyer would be highly advisable once this bill, or if this bill, capital I, capital F, if this bill becomes law.
Well, this is interesting. I mean, our communities are very concerned about rental rules, and some have tried and are implementing new rules, maybe more restrictive rules. And in the HOAs, this would address some of the grandfathering provisions, not exactly like condos, but more than it had before. Please share the results, Marinette, of poll 6. This is interesting, gentlemen. If I follow our conversation before, the yeses and the hybrids meet the in-person requirement, but the no's are the ones that probably should have a chat with their attorney to make sure that they can still do that. Okay.
I would agree. Yeah.
Roberto, are you done on 6:30?
Yes, sir.
All right. Well, that's a biggie. So thank you, Gary. There's a couple others. There's a Senate Bill 1966 is a DBPR that talks about qualification of board members. And this comes up in our world a lot, especially if there's a delinquency. Can you give our audience the snapshot of what that bill clarifies?
Yeah. So again, not passed yet. The only bill that we've spoken about so far that's actually been codified into law is that Senate Bill 72 that we spoke about early on regarding the liability, civil liability for damages under the COVID matters. But these 2 bills that I'm referring to right now are also on the governor's desk. They've been passed through the two houses of government, but they haven't been signed into law yet. So 1966 is an act that disqualifies, the act, as you're already aware, I should say, already disqualifies, as language in it, disqualifying certain board members from eligibility to run for the board if they're delinquent in their at all, period, is how it currently reads. So if there's any amounts due against the unit owner for any of any type, it's been interpreted to read that they're not entitled to serve as a candidate. The act now has been modified to identify that the delinquency is now only in their assessment payments rather than any other monetary obligations. So a person is considered delinquent if the payment is not made by the due date identified in the declaration. So if they don't pay their assessments for that period of time, they are deemed delinquent. If there's no due date specified, then that determines the due date to be the first date of the assessment period. Requires a board to adopt their annual budget 14 days prior to the start of the fiscal year. It's in conjunction with this concept. Otherwise, it's deemed a minor violation, and the prior year's budget will be readopted. But they're now asking that all budgets be adopted so that they're in line already in before the beginning of the fiscal year, which is typically how we would opine anyway. But and the requirements are pretty much identified in everybody's documents to do such a thing. The time isn't necessarily designated in most documents. But the big pull off of this one is that the disqualification as a candidate, you now need to look only at their assessment payments.
I think, Gary, this is a super important, especially for our self-managed communities. Often we take everyone who applies to the board and we put them in and don't necessarily think of doing, do they check all the boxes to qualify? So right. Number one, we all have to, it's the law. And this particular bill just clarifies some ambiguity that was there. So I think that's probably good. And right. What about 56?
56 is a simple one, but it's impactful. It changes the notice requirement for foreclosure actions, which were 30 days in the condo world and 45 days in the HOA world, and they have now been joined together, and the extension is actually going towards the HOA side, meaning it's now a 45-day notice requirement as compared to what it used to be, which was 45 days. Again, when this bill passes, so we're looking at potentially a July 1st change on something to this effect. And it also makes changes to the delivery of the notice, and the inclusion of attorney's fees have to be included in the notice. So disclosure as the amount of money owed is also now supposed to be included in that notice that's provided pre-foreclosure. So it's providing a little bit more time for the delinquent owner to make their payment before you proceed with the foreclosure action.
So those will or won't be signed into law by July 1,
the expectation is they will be signed into law. That's again, as Robbie said, every indication we're getting as the governor is supportive of these pieces of legislation. We've nothing against it. It had a fairly highly overwhelming approach in the House and in the Senate. So we are of belief that these are going to be codified and will probably be going into effect. The start date, the effective date will probably be July 1st on all the pieces of legislation that Robbie and the ones I just explained. They should all be going into effect July 1st is the target.
Okay, I got 2 questions left for you guys, and we got 4 minutes. The predominance of chat questions coming in here are on this vaccination and what policies we should do, and I'm going to just bunch a bunch of the questions into one, but the question is, a couple of the communities have pulled their owners, and the owners have said, we want to voluntarily show our vaccination cards and have a policy that, so it's not about forcing, it's about, can a community opt to do this? And I know that's kind of a loose question, but what are the advantages or risks of doing that?
Well, I'll start. Look, I think voluntary is a whole different world. I mean, if somebody voluntarily wants to provide that information, I certainly think that they're allowed to. I think we, especially in condo land, we need to be careful, because that is a medical record as far as I'm concerned. I think Robbie would join me on that. And there are restrictions about releasing medical information as part of that category that Robbie was speaking about of documentation that is considered part of the official records, but it's not releasable. So again, then you add in, I'm just using terms, HIPAA and other things like that. There could be some issues. So if there's any, and it goes to the bigger question that Robbie was mentioning, which I think is a very important one. Look, most of what I'm brokering into another topic, but it's joins together. Most of the issues that we've been dealing with is having reasonable restrictions. And then the big question is how are you enforcing that? I mean, we're not filing lawsuits. We're not, where there's a certain degree of enforcement. Some associations have leaned towards the fining. It hasn't really been thought to really go that route, because I just think the timing of instituting a fine and the time period and the issues that have risen, it just wasn't, it doesn't fit well to the situation. But that all said, again, to the particular question, people want to voluntarily provide their vaccination card to the office, and if they think that there's a benefit of that, that's fine. The question is, what is going to be done with that information? Because it can't be disclosed, it can't be utilized. We're not putting a list up that's going to say the following people, and I'm advising, any little friendly advice not to do that. So it may satisfy some side of this concern, but I don't really know if it has a massive impact in effectiveness in any kind of institution.
Interesting.
And just to finish that point, all of these discussions, which is how I prefaced my initial answer on this, James, I see it as a conversation with a client that you need to have. You need to weigh all of the issues, the function of the community, for example, the vendors. Are you going to have access to vendors? Are vendors going to want to come to the property and service the property if people aren't, wearing masks in enclosed areas? You see that there are certain issues that we need to take into account. Management companies, for instance, what is the management companies such as Castle? What are they going to do if this community all of a sudden goes maskless under the guise of everybody being vaccinated? So there are a lot of, tedious issues that I think those boards need to work through. I'm not suggesting it's not doable or impossible. I'm just saying it's part of a greater conversation that needs to be had between the board, its vendors, its servicing contractors, its legal team, etc.
Well, I will kind of end with some non-legal comments just from what we're seeing at our 400 communities. There's incredible pressure to relax the COVID policies that we've had. Both the governor and the CDC and everyone basically coming out and saying, if you're vaccinated, you don't need to wear a mask anywhere. And so what I've seen is a lot of our communities are relaxing the mask requirement. And they're basically saying, if you're vaccinated, you don't have to wear a mask, and we're not going to ask you for proof. And I'm generally, I'm taking 400 communities and just kind of averaging them with these comments. What that's done is it's kind of put the onus on the people who are not vaccinated or are concerned. So the onus used to be on, we all had to, and now it's on, look, if you're not vaccinated, it's up to you to wear a mask. That is what we're absolutely seeing. And the other thing I think that's going to be interesting as we go through the summer, hopefully this fades into the herd function taking over. But we probably have 2,000 cases of the flu. It's going to get to that level, and we certainly don't require masks for flu, at least not now. So it'll be very interesting to see how, are we going to go all the way back to the way we were before, or will there be policies that management or the law, their attorney are advising that we make some permanent adjustments in our policies? This is what we're having many discussions with. So I hope our audience can take from the conversation that there's no black and white answer, and they there's never been a time through this COVID, you spend the money and get your appropriate legal advice, especially with that COVID liability law. If we've asked our attorney for advice and we follow it, that's good protection in itself, probably from gross negligence. So, and then, I hopefully this will continue to fade from our reality, but I don't expect any more law in this area. I mean, we're not, the legislature's not even going to meet until next year now. So, guys, I want to thank you so much, both for your comments on kind of the whole, what do we do in our community, which isn't a crystal clear answer, and also the continued guidance about how we as boards live under the new laws that are passed. And there were quite a few laws passed, that's for sure. So we're very grateful. I know our audience is very grateful for your brilliance, and we're looking forward to our next show is on June 9th, and we have another one. Craig and I go back and forth on the 23rd. So Gary, Roberto, grateful audience.
Thank you.
And everybody.
Thank you very much, James.
Stay safe. Bye-bye.
All right, bye-bye. Thanks.
Likewise. Bye.